Check, check. Shalom, Lord in Christ. I'm Priest and Officer Shargapan of the Israelite School of Universal Practical Knowledge, started out of 1 West 125th Street, Harlem, New York. And under commanding General Yohana, we have been raising Black, Hispanic, and Native American men, women, and children to accept the truth, which is that they are the children of God. They are the children of Israel. They are the 12 tribes of Israel that you read about in the Bible. And today is history class every Monday here at the ISUPK. Joining me today, I have Priest and Officer Aishaya Allah. I also have Trooper Sha'ath Wan. What's going on?
Shalom, shalom.
How was your weekend? Good? Good? Okay. All right, well, listen. We are actually going to continue from a class we did about 3 weeks ago, which was discussing the black codes that affected court cases and the cruelty of slaves by slave owners or overseers. However, today we're going to go into some of the court cases, right, that affect slaves back in Louisiana and the Supreme Court cases and the Supreme Court down there. If you can please share the link, Babusha. Perfect. So we're going to pick up where we left off on page 6, right? Please read.
3 factors prevented the Supreme Court of Louisiana from hearing many appeals from criminal trials for cruelty to a slave during the antebellum period.
So here we're facing an issue where slaves were being mistreated very cruelly, facing diabolical punishment by slave owners, overseers, other people who might have been free people of color, right? But slaves had a very rough time in getting justice since they were mostly considered property from their slave owners or overseers. Keep going.
The most obvious is that there were few prosecutions of this nature, since slaves were often the only witnesses to such incidents.
Which would be true, right? Because if a slave master is disciplining, carrying some type of corporal punishment to his slave, which is his property, the only witnesses, therefore, would be the slave that is receiving the punishment and the overseer or slave master that's delivering the punishment. Keep going.
And since Louisiana law prohibited them from testifying against whites.
And what?
Since Louisiana law prohibited them from testifying against whites.
And even if the slave was the witness, the laws that govern Louisiana restricted, prohibited, did not allow slaves to testify against white people. Keep going.
Finding legally competent witnesses was difficult.
It was because, again, like we stated before, what white person would testify against another white person on how they handled their property, meaning the slave, right? Whatever that's a white man viewpoint was that the slave master had every authority they need to discipline their slave or to make the slave to be perfectly in submission. Keep going.
Many of whom felt that slave discipline was a private matter between slaveholders and their property.
As I just said,
were reluctant to testify in prosecutions for cruelty. Furthermore, as we will see in one instance, white juries simply refused to convict, despite overwhelming evidence of brutality.
Because, again, they're not going to be testifying. Check. They're not going to testify against another white man who's carrying out the responsibilities of owning property, a slave, and making sure that that slave abided by his rules. Keep going.
In such cases, Prosecutions of slave owners that ended in acquittal were not appealed and therefore do not appear in the records of the Supreme Court of Louisiana.
Right.
The third reason for the scarcity of criminal appeals is technical. The first Constitution of the state of Louisiana in 1812 limited the jurisdiction of the state Supreme Court to civil appeals. Until the Constitution of 1845 gave the High Court criminal jurisdiction, the court heard no criminal appeals.
Right. So the first Constitution of Louisiana, it did not allow the scroll back up. Leave it right there. It did not allow the state Supreme Court to handle criminal cases dealing with such incidences. They would only be limited to civil court cases based on the incident. And it wasn't until the 1840s, right, where the Supreme Court was able to gain this type of power to handle criminal court matters. And since before that, there weren't really cases that were brought to its attention. Keep going.
Appeals of criminal prosecutions for cruelty to slaves were therefore limited to the 16-year period from 1846 to 1862, although the court heard appeals of civil suits that involved death or injury to slaves throughout the antebellum period. The court was quite willing to sustain the property rights of slave owners in civil suits when their slaves were injured or killed by others, but the justices had little opportunity to affirm convictions of whites in criminal prosecutions. There were only 6 criminal appeals of cruelty to convictions to the court from 1846 to 1862. Each involved a slave man who died from the abuse he received.
So we're not gonna go into every single one of them. We're gonna go into a few of them, and I want to start here, Bubba Shaw.
Criminal convictions for cruelty. The first appeal of a criminal conviction for cruelty to a slave occurred in State versus Morris.
So in Louisiana, that was the first time that a white person, a slave owner, or overseer, was actually convicted for cruelty to a slave. Keep going. And we're about to learn how this slave, the punishment that this slave received and how severe it was. Keep going.
The defendant allegedly beat his slave to death.
What?
The defendant allegedly beat his slave to death.
Now, if we all remember in Exodus chapter 21, where it talked about the laws that govern how a slave, how a slave master and a slave are to be towards each other in terms of punishment. If the slave master beat the slave with a rod and the slave died, then the slave master would be held accountable. But if the slave did not die and lived for a day or two, then it's not certain that the slave died due to whatever injuries they may have sustained from the punishment. They could have died from something else. Keep going.
In a cruel and barbarous manner.
So right here in State v. Morris in the Supreme Court of Louisiana, they called this particular case and the punishment that was dealt to the slave as cruel and barbarous, in a cruel and barbarous manner. Let's listen to why they label this as cruel and barbarous.
Causing sundry dangerous and severe bruises and wounds upon the thigh, loins, and other parts of the body.
He caused extreme damage, bruises to the thighs, the loins, right, the groin area, and other parts of the body. This slave, this black man, person of color, right, sustained horrible bruises and injuries due to this cruel and barbarous beating, punishment. Keep going.
A hole in the abdomen.
A what?
A hole in the abdomen.
A hole in the abdomen, in the stomach area. There was a hole. Keep going.
The size of $1.
Of a what?
Of $1.
Of a what?
Of $1.
Now, if I'm not mistaken, those coins, those silver dollars, them things were humongous. Those things are, and had weight to it too. They're pretty big, right? So imagine a hole in the side, a hole in the stomach of this slave, the size of $1. So it's probably like maybe this big. That dollar. Keep going.
Which appeared to have been gouged out.
What?
Which appeared to have been gouged out.
That means that it was ripped out, like forced out, like gouged out. Like my imagination can't allow the words to effectively describe how something like this could occur. You know how when you hear the term, you gouge someone's eyes out, you meaning, you put your finger in the eye socket and you go underneath the eyeball and you pull out and rip the eyeball out. There was a hole the size of a dollar inside this man's stomach, as if to the effect where something was forced inside of it, hooked on the flesh, and then torn out, ripped out. Keep going.
Was the immediate cause of death.
And it was determined by the medical examiners and by the court and the evidence that was submitted to the court that was the immediate cause of death. The fact that this slave had a hole in his stomach the size of a dollar, which was determined scientifically to be gouged out, that was the cause of his immediate death. Keep going.
No one witnessed this treatment of the slave.
Why? Right? No one witnessed it because, again, the belief was that this punishment was a private matter between a slave and their slave master. Keep going.
Morris presented his oath in an affidavit denying his responsibility for the alleged cruelty.
Now, who can guess why he presented his oath in the affidavit?
Because that's all that was required.
Yeah, because I believe it was section 17 of the Black Codes. I think section 17. Section 17 of the Black Codes, it has like a clause in there where it states to this effect that to provide and prove a slave master's innocence, all he had to do was swear an oath that he was innocent. And that was enough evidence needed to acquit him, for him to not get for him not to be convicted. Keep going.
Slacky, the district judge instructed the jury that the oath was not conclusive evidence of the defendant's innocence.
Oh, really? So here, this judge is instructing the court that whatever he's talking about in the Black Code section 17, that's not good enough evidence. Keep going.
And the jury found him guilty.
What they do?
Found him guilty.
Thank the Lord that they found him guilty, because looking over the facts of this case, he abused and mutilated his slave. Keep going.
Morris appealed, claiming that under Section 17 of the Black Code, the owner's oath could not only repeal the presumption of guilt created by the section, but was intended to be conclusive proof of innocence.
So, of course, Morris submitted an appeal, went to court, and stated that under Section 17 of the Black Code, all the owner had to do was give an oath for his innocence. Keep going.
Justice George King, writing for the court, denied this interpretation of Section 17.
Now let's read the opinion of Justice George King.
Such does not appear to us to be a just interpretation of the act. The law creates a presumption of the master's guilt, which, in the absence of this express legislation, would not arise. It is founded upon the relation of master and slave, and the power of the former to maltreat the latter secretly and without the possibility, in many instances, of otherwise establishing his guilt.
So what he's stating here, right, is that that little clause, that law, that code, section 17, it actually allows some type of guilt to be kind of determined. Like, it's assumed that the master's guilty, right? And that's why the master would only need to give his oath. But then he goes on to say that due to the relationship between the master and the slave, it is acceptable to believe that this type of punishment, this type of treatment from a master to a slave is common and is more likely to happen, which which also helps establish the guilt of the actual slave master. Keep going.
He is consequently held answerable for the cruel treatment received by his slave while under his charge.
Because who was one, right? Who are the only witnesses in this case? The deceased slave and the slave master, right? Who was giving the punishment? The slave master. How did the slave master, right? You could tell that the slave master didn't deny that he beat his slave. He didn't say that he didn't touch his slave, he didn't beat him. It's already proven that he was punishing his slave. Due to the coroner's report, the examiner, the slave sustained all types of horrendous bruises, and the cause of death was the big hole in his stomach, right? So who else is going to be responsible for the cruel treatment to this poor slave that is now no longer living? The slave was in the slave was owned by the slave master. That's his property. He has the responsibility of taking care of his slave, of his property, right? This is how this white judge is thinking against this white slave owner. It's your property, it's your slave. You have authority over your slave. Your slave, all this happened to your slave under your watch and your care. If not you, who else is responsible for what happened? Keep going.
And when no person is present and is presumed to be guilty of the offense, unless, in the words of the act, he can prove the contrary.
Right? How can you prove the contrary? Your word, by basically just saying it wasn't me, I didn't do it, I didn't unalive my slave. That's not good enough. We want actual proof. It's not sufficient evidence. Your oath, by you swearing you didn't unalive your slave, you didn't do this. It's already determined just off the jump, that you have some culpability to the death of this person, of your property. Keep going.
It has been correctly urged by the Attorney General that the interpretation contended for by the defendant would enable the master to escape punishment by interposing his oath.
So the Attorney General, hey, we gotta correct this, right? Because anyone can just say, my oath is I did not do this, and now I'm scot-free. It can't be like that. Keep going.
When his guilt could be satisfactorily established by other testimony,
which would be the medical examiner, which could be the sheriff when they come, witnessing the damage that this slave had to undergo. The coroner or the medical examiner examining the body, like, wow, how did all this happen? Who could have done this to this slave? Right? Keep going.
Which could not have been contemplated by the legislature.
There's nothing that the legislator could think that. There's nothing that the legislature, that the law could think that would prove the innocence of the slave master, when all the evidence that's being presented is like a big red flag. This slave master did this to his slave. Keep going.
In such cases, the legislature could not have intended that the owner should escape punishment by interposing his own oath, or that the jury should acquit, notwithstanding their convictions from the testimony of the guilt of the accused.
Yeah, apparently they didn't think that this is something that would happen. They didn't think that this is something that was going to be used to try to escape punishment, right? They have no intentions of slave owners using this as a way to get out of the crime that they committed. Keep going.
State v. Morris is one of only a handful of cases in the appellate court records of the American South in which a state Supreme Court upheld the conviction of a slaveholder for cruelty to his own slave.
And this right here is a gem, right? Because even in today's day and age, we see things like this, but more modernized. We see a white police officer, right, using a firearm to shoot a black man in the back who's unarmed. And what happens? The majority of the time, what happens? Nothing happens. You know how it says the oath here? I pledge my oath that I did not do this. Well, now police officers can say, I was in fear of my life. How many times have we heard that in a court case? I was in fear of my life. I felt unsafe. I felt my life was in jeopardy, and that's why I did this.
Right.
So in a criminal court, you can't prosecute them. You can't convict them for unaliving. You can't convict them for murder. You can't convict them for manslaughter in the second degree, third degree, first degree. You can't, because of that little scapegoat, that little clause. I was in fear of my life, my safety. Just like back in the 1800s in Louisiana, well, according to Section 17 of the Black Code, I can just say, give my oath and pledge that I did not do this to this slave. It's basically the same thing, just 2024 version, right? Keep going, please.
Overseers, poor whites, and free persons of color were more likely to be successfully prosecuted for abuse of slaves than slave owners.
Right, so overseers, traditionally white people who were in charge of the plantation working for the slave owner, poor whites, who were poor, and free persons of color. So slaves that were free, black people that were free, Native Americans who were free, they were more likely to be convicted of cruelty or abuse to a slave of color than the actual slave owner themselves. Right? Keep going.
7 years elapsed before the court heard the next appeal of a conviction for cruelty. State v. Bass.
What?
The trial, 7 years elapsed before the court heard the next appeal of a conviction for cruelty.
So State v. Bass happened 7 years later. This happened, what, 18, scroll back up, 18 to what, 12? Keep going, don't say the year, huh? Wait, no, scroll down, keep going slow, pause.
1849.
1849. 1849, right? Right, that was number 26 you were highlighting? Yeah, 1849. So 7 years later, right? What's that, 1854? No, 1856? Something like that? You have State v. Bass. Keep going, please.
The trial court convicted William Bass and his stepfather, Harry McNabb.
So a father and son, father and stepfather were convicted for cruelty to a slave. Keep going.
Both described as Yowman of killing a slave named Joe.
Now, a Yowman, if you don't know what a Yowman is, it's like a squire. It's a person of high rank, of nobility, that works. Think of it as the overseer for the slave master. Think of it as a nobleman for a king, right? They had pretty high rank. Keep going.
Allegedly a runaway.
And Joe, the slave, was apparently alleged to be a runaway slave. Keep going.
According to the trial court record, Bass shot Joe out of a tree with a shotgun loaded with diverse leaden bullets.
So he shot him out of the tree with divers leaden bullets. Keep going.
The slave had climbed the tree in order to escape pursuing hounds. Bass's primary defense was that he was but a boy and also an orphan.
So the stepson, his defense was, listen, I'm just a kid. I'm a lad. I'm just a teenager. I'm only 13, 14 years old. I'm also an orphan. The rough life I've had to live. Keep going.
Prosecutor charged McNabb with aiding and abetting Bass in the shooting. The jury acquitted McNabb but found Bass guilty with a recommendation of clemency, as Bass was an orphan boy of tender age. So
they were trying to recommend that Bass, even though he was just a young teenager, give him some clemency. We feel sorry for him. Probably had a rough life. We don't want this to permanently stain his life. He has a whole life to hear. He has a whole life ahead of him. Doesn't that sound familiar?
Sounds real familiar.
Doesn't it sound familiar? So a white football player or a white swimmer or a white what's that score? Lacrosse player sexually assaulting a black woman and only getting probation because he's just a young man in his late teens, early 20s. We don't want to ruin his whole life. He has the whole life ahead of him. We got to give him clemency. However, keep going.
The Morehouse District Court judge sentenced Bass to only 30 days in jail and a fine of $300.
Keep going, sorry.
The state appealed to the Supreme Court on the basis that the district court judge had erred in giving Bass such a light sentence because the judge had allowed Bass's counsel to inappropriately introduce damaging testimony about the character of the victim in an attempt to justify the shooting. However, Justice Henry Spofford, writing for the court, upheld the decision of the trial court.
Leave it there, right? So the first judge in the first notice of the conviction, we're just going to give him 30 days, kind of like 6 months probation in today's day and age, right? Yeah, just give him 6 months probation. Don't get into any more trouble. Yeah, we're going to just give you 30 days in jail and just pay a $300 fine. The state was like, nah, this is not acceptable. What they did to this person and the evidence that was submitted, right, was not sorry, hold on. Had erred in giving Bass such a life sentence because the judge allowed Bass's counsel to inappropriately introduce damaging testimony about the character of the victim. Doesn't that sound familiar, right? Doesn't what they said, well, you know, he was a drug dealer. Even though he wasn't selling drugs that day, he was convicted drug dealer. You know, even though he was unalived by this white guy, you know, he was involved in gangs and he was always in gang activity, even though he wasn't doing nothing gang related that day when he died. Right? They said, oh, listen, he was a known scammer, right? And a thief and a robber, always breaking into someone's house and stealing stuff, even though that day when he died, he was not doing anything wrong. That's basically what that's basically what they did back then in the 1850s. Right there. That's a perfect example. They introduced testimony about the character of him to try to minimize the effect that he was unalived while in a tree, not hurting no one, not fighting back. He wasn't doing anything. He was just trying to hang on in a tree for dear life because of the dogs that were hunting him down, and he was shot and unalived. Keep going. So, all right. So then the other judge, the third judge, actually upheld the decision that the first judge made. Keep going.
2 of the other 4 criminal prosecutions for killing a slave involved free blacks.
Right. So, and these 2 court cases that you can read, State v. Taylor, and there's one other one. It was a free black man that was involved in the cruelty to another black man who was just enslaved. Right. You keep scrolling down. Hold on. Keep scrolling. Stop right. You can start there in 1858.
In 1858, during its next term, the court heard an appeal from 2 defendants in the second criminal conviction for cruelty to a slave by the owners, State v. White and Ward. The St. Martin Parish jury found George White and Clarence Ward guilty of inflicting inhuman and cruel treatment on a slave under Section 16 and 17 of the Black Code. And
it states that they found George White and Clarence Ward, 2 white men, guilty of inflicting inhuman. You understand? Look up the word inhuman, Baba Shah. Inhuman. Right? What does inhuman mean for those that are watching at home?
Lacking human qualities of compassion and mercy, cruel and barbaric.
Barbaric. Lacking compassion that a normal human would, right? They said inflicting inhuman and cruel treatment, inflicting barbarous treatments. No, when this treatment was being placed upon the slave, there was no compassion for that. This is another person, another human being. There was no compassion, no sympathy. No, maybe we just hitting him too hard. You know, maybe he doesn't really deserve this. It was inhuman and cruel treatment. Keep going.
And the judge fined each $400.
What?
and the judge fined each $400.
And all the judge did was say, listen, $400. That's what you're going to pay for unaliving this person, your property. Keep going.
The slave had died from his wounds. White appealed the conviction on a legal technicality, asserting that an 1855 legislative act relative to crimes repealed sections 16 and 17 of the Black Code. White also asserted that if not repealed, sections 16 and 17 did not require a criminal prosecution for cruelty. He claimed that he was entitled to a civil trial for damages rather than a criminal prosecution.
So he's trying to use the Black codes and the loopholes to say that this shouldn't be a criminal case. This should just be a civil case. Keep going.
The Supreme Court's opinion, written by Chief Justice Edwin Merrick, rejected these arguments and upheld the conviction.
Well, according to the Chief Justice Merrick, he's like, yeah, we're not having that. And here's the opinion. Keep going.
Finding that the Act of 1855 did not repeal sections 16 and 17 of the Black Code, the court's opinion was strongly in favor of criminal prosecution. We know no law which requires the prosecution under these sections of the Act of 1806 to be conducted as a civil suit.
Right? There's nothing that this Act of 1806 says that this has to be a civil suit. Keep going.
On the contrary, we think that the terms conviction and offense used in them imply a prosecution by information or indictment. Moreover, the first offense specified in section 16, viz., the offense of killing the slave of another, could be prosecuted in no other manner.
Right?
You
unaliving the property of someone else, the slave of someone else, it automatically has to be a criminal prosecution. There's nothing else that can be done. Keep going.
The last criminal prosecution for killing a slave, State v. Davis, occurred in 1859. The record of the lower court no longer exists. The opinion of the Louisiana Supreme Court indicates that a grand jury indicted W.H. Davis, a white man, for felonious assault on a slave by willfully shooting at him with a shotgun loaded with gunpowder and diverse leaden shot. Davis's attorneys filed a motion to quash the indictment on grounds that no law allegedly existed that forbade a free person from purposefully shooting at a slave with intent to kill.
Read that again.
Davis's attorneys...
Read it slow, though, because this is crazy what this white man is trying to propose. Keep going.
Davis's attorneys filed a motion to quash the indictment.
His attorney, this white man hired his attorney, and this attorney was like, listen, I need this whole indictment to be gone because...
on grounds that no law allegedly existed that forbade...
There's no law, because there's no laws that exist that forbids, that doesn't allow...
a free person...
like me, a free person...
from purposefully shooting at a slave...
for purposely shooting at... There is no law that has been created that stops and prevents a free person from purposely, deliberately, with intent of shooting at a slave. Keep going.
with intent to kill.
With the intent to kill. There's no law that says I can't do that. None. There's no law that says I can't do it. Therefore, I right? I'm speaking on behalf of Davis, right? Davis, he says that by law, he can purposely, as a free person, shoot at a slave with the intention, the desire to unalive him. He's protected by the law to do that. Keep going.
The Morehouse Parish District Court ordered Davis's indictment to be quashed.
What?
The Morehouse Parish District Court ordered Davis's indictment to be quashed.
So the first court, the Moorish Parish District Court, was like, you know what? This white man is right. There's no law that prevents him from wanting to shoot at a slave and wanting to kill him, right? There's no law that says that. Keep going.
But the Supreme Court reversed. The Supreme Court reversed.
When it went to the appeals, the Supreme Court said what?
Reversed this order.
They're like, yeah, that's not going to fly. They reversed that decision. Keep going.
Reinstated the indictment
reinstated the indictment, you're going to get in trouble for what you did. Keep going.
And remanded the case to the lower court for prosecution.
And send it right back to the lower courts so that way it can be criminally prosecuted.
Associate Justice James Cole wrote for the court, slaves are treated in our law as property and also as persons.
What did the Associate Justice James Cole say?
Slaves are treated in our law as property and also as persons.
And a person.
This section of the Act of 1855 pertaining to crimes then applies to assault upon a slave or upon a free person.
So therefore, according to the Act of 1855, then what you did applies to this slave. Keep going.
Owners of slaves abused by others often chose to bring a civil action for the value of the slave if the slave had died as a result of the abuse.
So here we're talking about civil suits. We're about to get into civil suits that involved cruelty to slaves. Keep going.
Or for the amount the injury had diminished the slave's value. It is in these cases that evidence of cruel treatment most often appears.
Right, because again, they had so many issues with criminal cases because of the Black Code. It was more common to see cases of cruel treatment to slaves in the civil suit, because again, being a slave being a person's property, if the person's property is damaged or loss of life has happened, then damages must be paid back to the owner of that said property. Keep going.
But clearly the property value of the slave took precedence to obtaining a just punishment for the perpetrator of the barbarous treatment.
Read that again.
But clearly the property value of the slave took precedence to obtaining a just punishment for the perpetrator of the barbarous treatment. So
the value of the slave, right, was more important when obtaining the punishment for the person that committed these acts. Keep going.
Even a purely civil matter would have brought the incident to the attention of the public prosecutor, who could have chosen to begin a criminal prosecution.
Right, because I could understand, right? Let's try to make two examples, right, to better understand this. A slave, I hate having to use this, but to be in context of the mindset of these white men. A slave master gives his slave to another white person to use for work. The slave, that white person that is now using the slave, puts him in a dangerous situation where he damages his knee and his knee now has to be cut off, right? Because he was under the supervision of that white person and he got injured while working for that white person. Now the slave no longer has a knee. He loses he loses the amount that he would produce or have his slave master gain from the work of having his leg. Now, since he no longer has his leg is cut off at the knee, his value to his master diminishes. Damages must be paid to the slave master. Then we have cases where someone is actually physically being cruel and beating, purposely injuring a slave, which causes a loss in value to that slave, which reduces the amount of money that the slave master can gain. We're talking about those kind of cases here, right? So when that's the case, we already know that physical force is being used against that slave, and that is why many of the times the criminal prosecutors could have easily taken cases like this and made them criminal cases, but instead, many of them just stayed as civil cases. You say something? No.
The scarcity of criminal prosecutions was the result of solidarity among whites.
What?
The scarcity of criminal prosecutions was the result.
The reason why there weren't cases like this being turned into criminal court cases is because of what?
Solidarity among whites.
Because again, white people are not going to convict their own people. Again, in this time period, I don't know. This is so relevant. You gotta said it has to be said more than once throughout the class. White people are not going to convict other white people.
Right.
White people are not going to testify against other white people. White people don't want to be in a position against other white people because all white people had the mindset that whatever happened between a slave and their slave master is between the slave and the slave master. It's no one else's business, regardless of what happens after. It's their business and no one else's. Keep going.
And especially among slave owners, which often prevented whites who witnessed the atrocities or who had seen the physical evidence of excessive violence from pressing charges or even reporting slave abuse to the authorities.
Right? Because who's going to do that? I'm a slave owner. You're a slave owner. I ain't trying to have you go to court for abusing a slave. I'm probably doing the same thing. White people, slave owners, they got to stick together. Keep going.
Although slaves were often the sole witnesses to cruelty to their fellow bondsmen, the Black Code disqualified slaves from testifying in court against whites or free blacks.
Right? They couldn't. That's new to hear against free blacks, right? But slaves can't testify against white people at all. Keep going.
Appeals to the Supreme Court of Louisiana in civil cases involving cruel treatment or senseless, unprovoked violence against slaves can be divided into three categories.
What are these three categories?
Cruel treatment of slaves by strangers, by overseers, and by their masters. The last classification, that of abuse by masters, was the least frequent. No doubt because slaves disqualified from testifying in court were often the only witnesses to such incidents, and masters would be unlikely to report the event themselves.
Yeah, the white man is not going to snitch on himself. He's not going to pick up the phone and call 911. Yeah, I just finished beating my slave very inhumanely. I stepped over the boundaries. I was pretty barbarous in my treatment towards him. The slave owner's not going to call the sheriff and say that. Keep going.
On the other hand, masters were much more likely to report acts of violence by others that injured or killed their valuable slave property.
But the slave master is more likely to report a crime against his property by other people. Keep going.
Slaves who stole animals and produce often risked serious gunshot wounds and even death, though their infractions might have been minor.
Now, in this case, in Allen v. Young, it's a free black man that owns a slave, and his slave was stealing from other people, right? Scroll down, Bubba Shaw. Stop right there. No, keep going. Start in the 1850s.
In the 1850s, the Supreme Court of Louisiana heard several appeals in which owners sued others for shooting their slaves for stealing animals or produce. Stealing sugarcane resulted in the death of a slave, and the lawsuit Carmouche v. Buis. Narcisse Carmouche brought a civil action against his neighbors, Francis P. Buis and his son Louis, for the value of a slave named John. Testimony indicated that a gang of slaves had been making nightly raids on Buis's sugar plantation to steal cane. Determined to put an end to the nocturnal depredations, Buis ordered his son and his overseer to arm themselves and keep watch over his fields. Both were instructed not to fire upon trespassing slaves, but merely to fire warning shots to frighten them. When Buis's son saw John climbing the sugarcane field's fence, he fired without taking aim and by chance mortally wounded the slave. The Pointe Coupé Parish Court awarded Carmouche $800. In his appeal, Buis contended that he had the right to defend his property. However, the Supreme Court justices ruled that he was liable for the slave's death and resulting property loss to Carmouche.
Right, so although, he didn't have the intent to shoot him, trying to scare them, he still damaged another white man's property. And therefore, even though they were stealing his sugarcane and trespassing one, stealing his property 2, right? 3, he has the right to protect his property. In the case of all that, he still unalived the property of someone else and had to pay the damages for that. Because he couldn't prove that they were stealing their goods. They could probably prove they're about to trespass. Keep going.
The difference between this case and the decision in Elaine v. Young lay in the nature of the slave's acts. Regis's attempt to seize a firearm was a felony. In Carmouche, John's offense was petty theft. Justice Isaac Preston, writing for the court, held that homicide was not necessary to prevent a misdemeanor, and that the killing of John was unnecessary for the defense of Bous's person, family, or property.
Right. It was unnecessary to shoot him. Other matters could have taken place. Keep going.
8 years later, the court heard an appeal from the District Court of Plaquemines Parish, McCutcheon v. Angelo, which involved the shooting and blinding of a slave named John Hall, the property of S.D. McCutcheon. The plaintiff brought a civil action for $3,000, $2,000 of which was the alleged value of the slave, and $1,000 for his future maintenance, as McCutcheon claimed the slave was worthless as a result of his injuries. Angelo claimed that he shot the slave because he had observed him lurking about his chicken house. When the slave realized that Angelo had seen him, he fled, ignoring Angelo's order to stop, whereupon Angelo shot him. The attending physician testified that Hall had been wounded 8 times, including 1 shot in one eye and 2 in the other. The lower court judge awarded McCutcheon $1,500, stating that Angelo had used excessive force for petty larceny. In his appeal, Angelo asserted that his actions were justified as the slave was in the act of committing a felony and that he had refused to obey Angelo's order to halt. The Supreme Court ordered Angelo to pay the damages assessed by the lower court. Chief Justice Edwin Merrick wrote the opinion dismissing the defendant's assertion that chicken stealing was a felony and rejecting Angelo's contention that shooting was justified by the slave's refusal to stop when he commanded.
Yeah, so they got rid of his statements. Like, none of that. What you said justified you taking aim and shooting at him. The crime that he was committing or may have committed is not punishable by death, which you dished out to him in your own sense of judgment. He was liable to pay the damages to the slave owner. Keep going.
It is true that it is provided by law that if any slave shall be found absent from his usual place of working or residence without some white person accompanying him and shall refuse to submit himself to examination, any freeholder shall be permitted to seize and correct him, and if he should resist or attempt to escape, the freeholder is authorized to make use of arms, but to avoid killing the slave. But should the slave assault and strike him, he is authorized to kill him. Justice Merrick's opinion made no mention of an 1818 case, Jordan v. Patton, in which the court ordered an owner fully compensated for the blinding of her slave to transfer title to the owner of the slave who caused the injury. That the Supreme Court considered the well-being of the slave who had been owned by the same mistress for many years, but denied that the slave's future situation had relevance under the law. The difference was that in Jordan, the slave was injured by another slave, while in McCutcheon, the slave was gravely wounded by the very person to whom the title would have transferred. Although in Jordan, the court stated that cruelty and inhumanity ought not to be presumed against any person, Angelo's excessive punishment for chicken stealing went far beyond the presumption that further abuse of the slave might occur. During the same term that the court decided McCutcheon, it also heard the appeal of Gardner versus Thibodeau, a civil suit in which Edward C. Gardner sought to recover the value of his slave Charles. The slave had been in the act of stealing chickens when John Thibodeau shot and killed him. A witness stated that after the shooting, there were chicken feathers from the chicken yard to the place where the Negro was lying. Thibodeau admitted that he had shot Charles because he ordered the slave to halt, and the slave continued to flee. The District Court of St. Landry Parish found for the defendant, citing an 1857 act which provided that it shall be lawful to fire upon runaway Negroes who may be armed when pursued if they refuse to surrender. Thibodeau contended that he was justified in shooting Charles because he was running away and was armed. Chief Justice Merrick, writing for the court, rejected this argument. It is proved that a knife was found in the pocket of his coat after the body of the Negro was removed to the residence of the plaintiff. The coat was lying at the feet of the boy, and the knife was a butcher knife 6 or 7 inches long. This does not bring the case within the statute. The defendant did not pretend, as we have seen, that he killed the slave because he was a runaway and armed, but because he was stealing his chickens and run, and did not stop when commanded. If it be assumed that the Negro had his coat on when he was stealing the chickens and the knife was in the pocket, the defense still fails because it is now shown that the slave was a runaway. So far from being a runaway, the proof makes it sufficiently certain that he was out for no other purpose than that of stealing chickens, 2 of which were found by his house. The proof shows that he was addicted to theft, but there is none tending to show that he was a runaway. Our law does not justify the killing of anyone for a theft, and the defendant is left without sufficient justification. The Supreme Court reversed the decision and awarded Gardner $1,150. Citing McCutcheon v. Angelo, the court ordered Thibodeau to reimburse Gardner for Charles' value. Duperrier v. Dauterive was another case involving an owner unable to recover from those who shot his slave for ignoring an order to halt.
Start right here. Scroll down just a little bit. Keep going. You can skip all that and start here, going to overseers.
Civil suits against overseers for cruelty. The Louisiana Supreme Court heard several appeals involving slaveholders who sued their overseers for brutality and injury to their slaves. Slaves' hatred towards overseers in the American South is legendary.
Just like hatred towards officers today.
Historian Kenneth Stamp and others have charged that overseers had a marked preference for using physical force in managing their charges. Since slaves did not accord overseers the respect of owners, physical coercion was often necessary to induce obedience.
You know what that sounds like? That sounds like you not hating the CEO of your job because you can't do nothing to him and he pays your salary, but you hating the officer because the officer is accustomed to slamming your kids against the wall. That is what that equates to. You don't hate Jeff Bezos and Mark Zuckerberg, who allegedly selling, compromising your information on Facebook, but you hate the LAPD, you hate the NYPD, you hate Chicago PD, you hate Houston PD, you hate all of them, right? But you love Jeff Bezos because you get everything you want off Amazon for cheap. Keep going.
Section 33 of the Black Code provided for criminal prosecution of persons who beat slaves belonging to others without sufficient provocation, as well as providing financial compensation for dead or injured slaves. However, not one of these cases involved criminal prosecutions. All were civil suits to regain the value of the lost labor of the slaves if they were unable to work as a result of their injuries, or for the price of the slaves if the overseer permanently disabled or killed them. Often, the slaveholder demanded that the court reduce the overseer's salary as compensation for the loss. Overwhelmingly, the Supreme Court ruled in favor of the slave owner, regardless of the decision of the lower court. Details from the lower court cases often reveal that overseers deserved their reputation for harsh and often excessive measures to maintain discipline and maximize productivity. The lack of criminal prosecutions, despite overwhelming evidence of barbarous treatment, demonstrates the failure of slave law to provide protection for the basic right to be treated humanely and the resultant inadequacy of the courts in dealing with cruelty to slaves. There is no real evidence of a shift in jurisprudence in appeals concerning cruelty during the antebellum period. Despite changing times and personnel, the Supreme Court almost always supported the property interest of the masters against their overseers, except in unusual circumstances.
Which would make sense, right? Scroll down a little bit. Keep going. Keep going, keep going, keep going, keep going. Keep going. 2 more pages. Keep going. One more. Keep going. And you can stop. Okay, listen, check this out. Listen, if you want this article, you can just put a message in the chat and we'll just send you the link to this article. Because there's nothing but just case after case dealing with this subject matter. The whole point of bringing this out, right, for history class is to provide you with more information, right, of the treatment of slaves and people of color. It's to show how the law is still against you, whether we're in 1858 or 2024. The law works in favor of our oppressors, even until this day. Any questions? No? Can you go to the chat real quick? All right, no problem. All right, so we're going to end the class right now. All right, so this has been the ISUPK History Class Monday. I'm Precinct Officer Sharga Pond. Joining me is Priest Ashayala and Trooper Sha'afwan here in the building. ISBK, the Israelite School of Universal Practical Knowledge, was started out of 1 West 125th Street, Harlem, New York, under Commanding General Yohana. And since 1969, we have been teaching the truth of the Bible, which is that so-called Black, so-called Hispanic, so-called Native Americans are the real Jews of the Bible. Shalom.